I think I'll kick us off. Thank you everyone for taking the time to attend today's webinar. The goal of today's event is to go through the fundamentals and lesson learned on IP protection. Whether you're a researcher, technology innovator, or entrepreneur, hopefully you'll find today's webinar helpful for your own experience. And today we have 4 speakers with us. I will introduce them each briefly. So our first speaker is Carl Ronald, who is a shareholder in the corporate, commercial, and emerging technology groups of Babs Colan law firm. He's a highly experienced intellectual property attorney who has been representing clients large and small in the prosecution, licensing, and enforcement of their patent, copyright, and trademarks for more than 20 years. As part of his practice, he counsels clients on how to protect their inventive creations domestically and in foreign jurisdiction, as well as providing advice on freedom to operate, infringement studies, portfolio analysis, and white space evaluations. He also routinely prepares and negotiates commercial and employment documentation relating to the ownership, use, transfer, sharing, and joint development of existing and new intellectual properties. And our second speaker is Frank Young, who is a partner at ADL Ventures and the founder and CEO of Liatris, which is an advanced insulation materials startup. Frank has helped scale up ADL's open innovation offerings after Liatris went through ADL's DOE-funded Building Material Challenge as an applicant. And currently, he works closely with ADL's commercial and government clients on key commercialization and scale-up initiatives, including the ABC Collaborative and American-Made Prizes for DOE. And our third speaker is Tom Mills, who is the CEO of Pace Controls, an award-winning DOE-funded developer of Edge Plus Cloud, smart grid solutions, and AI for 90% of the machine that cool and heat our world. The company has active and growing licensing and joint development collaborations with global OEMs. Tom is also a co-founder of Elysian Holdings, an innovative compostable container technology company. And our last speaker is Josh Cable, who is the CEO of InventWood, an innovator of revolutionary wood-based material technologies. He began his career in the financial service industry and served in a variety of positions in product management, marketing, and analytics with over 10 years of corporate experience in the United States and Asia. Josh graduated with a BA from Harvard University and holds a CFA designation. Okay, so now I will walk through today's agenda. So we've done the speaker introduction. After this, I will hand it over to Carl to give a presentation on different types of intellectual property rights and how to protect them. And after that, our 3 other speakers, who are all startup founders themselves, will share some of their own personal experience on how to protect IP. After that, we'll open up to Q&A. Feel free to drop your questions throughout the webinar in the Q&A section. Okay, so now I'll pass down to Carl.
Thanks, Jan. Good morning, everybody. It's morning, I suppose. Everybody, most people are. It's 1 o'clock here in Pittsburgh. Thanks for joining today. Yep, mute is off so you can hear me. That's good. So today, as Jan mentioned, I've been practicing patent law and IP law for a little over 20 years in various capacities. I've represented folks, but I've also sat on screening committees for angel groups. I have acted in due diligence capacities for those same angel groups, and I've also been an investor myself in startup companies. So I have maybe a unique perspective on a lot of the issues that startups have with respect to IP. I think it's interesting before we get into it, and we're going to talk about 4 types of IP today that felt especially relevant to sort of startup or new companies, patents, trade secrets, and the differences especially between the two, because there's a natural tension there, but also trademarks and copyrights. Patents and copyrights are actually in the Constitution. When the founders put the Constitution together and set up our government, they gave Congress the power to protect those two things, and they have done so through legislation. So first, let's talk about patents. So a patent, by definition, is a government-issued right? It comes from the Constitution and through our Congress for a limited time to exclude others from making, selling, using, or importing that which you claim is your invention. And that's in exchange for teaching the invention to the world. So let's unpack this a little bit. So for a limited time, right, it used to be that patents were good for 17 years from the date of issuance, right? You file your application. The reality is it takes a couple of years before an examiner looks at it, which is a little sad, but that's the way it goes. You can, by the way, pay to play. You can pay an extra fee, a couple $1,000s, and get them to look at it within a year if you're fairly certain that you're going to get a positive result. It might be worth it. But as it stands, it takes about 2.5 years for an examiner to look at it. And then you'll have a back and forth about whether or not you can get the patent, what the prior art is, things of that nature. Should your patent ultimately issue? It used to be that you got 17 years of protection. Now, due to some harmonization activities and treaties with other countries, it's 20 years from the date of first filing. So, we'll talk about the different kinds of applications later, but whether you file a provisional patent application or you file a non-provisional patent application, your protection, should you ultimately get a patent, will be for 20 years from the date of filing, which is also called, by the way, your priority date. And so you have the right to exclude others. Now, that's different than saying you have the right to do it, because what you have to do is go to court to stop others from, it's a sort of private enforcement right to stop others from practicing that which you think is your invention. So it's a government issued right for a limited time for you to stop others from making that which you claim is your invention, using it, selling it, or importing it in exchange for teaching it to the world. So I underline teaching because that's an important juxtaposition with trade secrets in my mind. Trade secrets, I didn't start my timer. Oh well, we'll wing it. Trade secrets, you have to keep them secret, but patents, on the other hand, what you're doing when you file a patent application is that you're telling the world how to do something that you've discovered works better than anything else, which solves a problem in the art. And you have to teach them the best way you know how to do that in the patent document, both with text and with drawings, so that somebody of ordinary skill in the art can understand how you did it. Different types of patents, right? So there's basically 3 different kinds of patents. These are issued patents. There's utility patents, which are what we typically think of as a patent, right? It's a device or a mechanism, or it's a method of doing something that is useful to people, right? That advances the state of the art in a particular industry or multiple industries. By contrast, design patents are really about the look and feel of a product or some sort of useful item. So design patents protect ornamentation or an ornamental aspect of a useful item. And I'll provide you with an example in a little bit that Apple has on one of their phones. But suffice it to say, let's sort of like an inlay on a chair or a table, some sort of like a robot, for example, that looks a certain way, right? Maybe it has rounded joints instead of squared off joints, so it looks softer. These are the types of things that are kind of soft and are protectable with design patent. And then finally, there's plant patents. I don't deal with these. This is an extremely narrow kind of thing. Usually it's genetic modification for disease resistance of corn or something like that. We're not going to really talk about it today, but I wanted you to at least know that that kind of thing was out there. And so then some people confuse the types of patents with the types of patent applications. So when you file a patent application, there's basically 3 different types, right? There's a provisional, that I've kind of discussed already, but provisionals are basically placeholders, right? All you need to file for a provisional is a description of what your invention is and at least one picture or one image or one drawing. You can file it. It's good for a year. It can't be extended. Nobody's ever going to look at it. Well, I take that back. To the extent there's a priority fight later, like who filed first, because America is a first to file country now, and you have to rely on that early date, the court will look at your provisional filing to see whether you had possession of the invention, whether you actually provided enough detail so that somebody of ordinary skill in the art could practice the invention. So that's a provisional, right? It's quick and easy. It is usually low cost, and you're on file with a priority date, a disclosure date, and it's good for a year, and you can't extend it. Before it ends, you have to file what's called a non-provisional patent application. Now, the non-provisional is what we typically think of as a patent application. It's going to be examined by the examiner at the patent office. It's got claims in it. It has a number of pictures. It has a number of alternative ways to practice your invention. It's a very clear, well, sometimes not so clear depending on the drafter, but it should be a clear exposition of that which you intend to protect. It ends in claims that are the metes and bounds of your invention. They are, in essence, what you can stop others from doing. And I'll provide you with an example, and we'll walk through what a claim is and how it interfaces with the drawings. And then finally, there's a PCT application, which is also called an international application. That, in essence, the PCT is the Patent Cooperation Treaty. It's basically how you get foreign protection easily, right? So you file one application designated as PCT, and then for 18 months or 30 months, depending on how you want to do it, you are patent pending in every country that is signatory to the PCT, to that treaty, which pretty much is every industrialized country these days, if possible. One exception is Taiwan. It's the only one I can think off the top of my head, but just about every other country is signatory to this treaty. And you can wait until either 30 or 31 months after your initial filing, whether you started with provisional or non-provisional, however you initially filed. Either 30 or 31 months after that, you must enter what's called national stage in every country where you want to seek protection. In every country where you don't enter national stage, your patent will be abandoned. So if you file at your PCT deadline, the European Union, which is a region, and I'll get into that in a second, India and Australia and the US, right? You are on your way and you have to prosecute your application in each of those countries, which usually means you have to hire an attorney in those countries. And your patent attorney here in the United States usually has contacts there that can handle that. And they will explain to you the different phases and different steps along the way. But you would be patent pending in those countries only at that point. And you would have abandoned your attempt to get protection in every other country that is signatory to PCT. So probably a little more complicated than I intended to go, but suffice it to say, PCT is a way to get protection in other countries where you can delay your filing in those countries. And often people do that because they want to see, what countries you're getting traction in, or they're not sure how the funding is going to work because this is quite expensive. I mentioned the EU as well. So the EU actually has a European Patent Office where they will allow you to prosecute the application. And if you get a patent in the EU, you must then validate in every country where you want protection, essentially pay another fee. But there's no additional evaluation or examination of your patent if you get an EU patent in each country where you actually want to validate, where you actually want protection. So it's a centralized examination. And then each country just says, yeah, we trust those guys at the EU. So that's a lot of times if you have a product or a process that has broad commercial implications in the EU, that's the route you want to go. All right, so within the types of patents, utility, design, and plant, as I said, we're going to be talking mainly about utility patents. Utility patents are available for things that are processes, devices, compositions of matter, and they have to be three things. like three-legged stool, so to speak. They have to be novel, they have to be useful, and they can't be obvious in light of what has been published or patented before. So novelty means, and the reason this is important, is that it can't have been disclosed in a writing or verbally prior to your filing, right? In the US, there's a wrinkle to that. We have 1 year in which to file a patent application after we disclose it. But that clock is very important, first of all, because if you don't file within a year, you lose the ability to get a patent. Say you disclose it at a trade show, right? Number one, the rest of the world doesn't give you that year. And so if you disclose it at a trade show to people who don't have an obligation of confidentiality, then you lose your rights everywhere except for the US instantly, right? If you disclose it at a trade show and only want protection in the US, you do have that 1 year in which to file. So this is an important point. And often I'll get clients or people call me, last second, hey, I'm doing a trade show on Saturday. I'm going to present on Monday. Do I need to worry about anything? I'm like, well, if you want to try and protect anything that you're doing, then yeah, you should consider filing a provisional really quickly. And oftentimes I'll just take the presentation, ask them a few questions, file the presentation along with an additional description, short description, and that's sufficient. I don't want everybody to be aware of that. The novelty, it can kill your patent. Useful, that's obvious, right? It has to be something that has utility, something that advances the state of the art. Non-obvious, that's an interesting one because it's so gray, right? It's in the eye of the beholder, a little bit. The way this happens with examiners is that you file and you're seeking to protect something, an examiner looks and it's novel, right? It isn't exactly disclosed in any prior art publication or any prior patent application. However, there's 2 or 3 that are super close and they disclose certain elements of your application such that they disclose all the elements. So what the examiner is going to say is, look, this imaginary person having ordinary skill in the art who knows every single previous publication and every single patent that's out there would know that if you added A, B, and C, 3 different references, then it would be obvious to do what you're doing, right? And so then that would be a rejection based on Section 103 of the Patent Act, which is obviousness. And so that goes to your attorney. Your attorney says, no, that's hogwash, right? There's no way that somebody would be motivated to put these 3 together because one of them is in a completely different art. It's dealing with outer space and we're doing construction equipment, something like that, not analogous art. There's all sorts of arguments about why the examiner should not have put those 3 together. But that's just kind of how it works out during prosecution. But the obviousness part is something that you can argue back and forth about, and ultimately you'll have to get over if you want to get a patent. I also put eligible subject matter on here because computer software is something that is tricky, right? So technically, computer software is an implementation of a method of doing something, which theoretically is protectable on a computer. However, there are certain things that the government has said statutorily and through judge-made law that we can't protect. Some of those are naturally occurring phenomena that we discover, like you can't patent gravity. You can't patent certain mathematical algorithms. Things that express things that occur in nature that you discover can't be patented. You also can't patent things that are like games. So a card game can't be patented. It's deemed to be a well-known interaction between people. So even if, like I have a client in the casino industry and they constantly come up with new games to keep people coming in, or at least pre-pandemic they did. And so, they're like, can we patent this? I'm like, well, absent anything that is sort of, you can hold or touch, that is a different sort of element that goes with the game, it's going to be a tough road to hoe, right? Computer software, similarly, the judges have said, the Supreme Court has said that, and this is the latest, I'm summing up probably, 50 different opinions within a statement here. It's just always dangerous. But the way that I look at it is unless the computer software improves the operation of a computer or a device demonstrably with some sort of objective measurement, you're probably not going to be able to patent software. Your results may differ. Talk to your patent attorney, but that's kind of the general way that I look at it. All right, so I thought it might be cool to sort of look at an example, right? This is an actual patent for the beerbrella. This is US patent number 6637447. And so for shorthand, patent attorneys always refer to the last 3 digits. So this is the 447 patent. And this is for a container of beer that you have a clip that has a shaft that goes up to the umbrella. I don't know how they got a patent on this, but they did. But it's pretty narrow. So I'm going to go to the next slide and show you the patent claim that goes with this patent. So this is the patent claim. This is actually what the entity or person that owns this patent, this is what they own. Combined beverage container and shading apparatus, right? Comprising the beverage container, which is the beer bottle in this case, a means for removably attaching the apparatus to the beverage container. Well, the means for removably attaching is this thing, right? This clip. They use the term means for removably attaching because it's broader. They're attempting to encompass every single way you could connect it to the beer bottle. The shaft coupled to the means for removably attaching. It's kind of an awkward phrase there, means for removably attaching. But, they often say patent attorneys are our own lexicographers, so we can sort of make up words. And as long as we're consistent, we define them, that works. So the shaft is coupled to the means and extends vertically with respect to the beverage container, right? So that's number 3 here. Attached to the clip, extends vertically, and then an umbrella. But I'll bet you during prosecution, the examiner said, you know what, I see something else that's working, so you have to narrow this somewhat. So they said, all right, wherein the means for removably attaching comprises a clip provided to attach the beverage container by means of spring, action, and friction. So if we look at this, somebody who is a competitor might say, well, hey, it looks like spring, action, and friction are required. They are an element of the claim. So what if I take this and I make it a sleeve instead, right? It's not connected by spring action. It just sleeves over the bottle. And actually, I can make one that also has thermal capabilities, right? So that might be a way that you try to get around this patent if you're a competitor and there's some commercial value to this. So that's what a claim looks like and how you might approach trying to get around an existing patent, right? From an infringement analysis, in order for an item to infringe this claim, it has to have every element. So it has to have the beverage container for containing a beverage. Well, what if I just sell this by itself? Right? I'm not going to directly infringe, but I might be a contributory infringer depending on how I sell it. So you have to be careful. There's different ways you can get in trouble, but you need to have all of these to directly infringe. And here's an example of a design patent application, or actually a design patent. This is owned by Apple. And it's tough to see on here, and these are often hard to interpret. The dashed line is something they're not protecting. They're only protecting the solid lines. And in this case, they indicate they're protecting the sort of the gray portion, the blacked out portion on the top. It's a grid that makes it look darker. So they're really only protecting with this design patent how the surface looks, how the viewable surface looks. So there's an area where people probably remember this phone. There's an area where there's a screen and then there's a circle area where there's a home button at the bottom, right? It's really the look and feel though. It's not the sort of functional aspect of the home button. All right, let's leave patents for now and talk about trade secrets. So unlike patents, which you're telling the world what you're doing, trade secrets have to be secret. Or any secret that nobody knows about, right, outside your company, that gives your company a competitive advantage, right? You must take steps to keep it secret. And we're talking major steps, right? Limit the knowledge of the secret to those who have a need to know within your own company. Make sure they're tied down with confidentiality agreements, and employment agreements that limit their ability to tell anybody about it. This can be free, right? You don't file it with anybody. It's not a government given right. It can last forever. Those are benefits. The downside is what happens when the employee gets mad at you, leaves the company and takes this stuff with him, right? So you can sue him or her, but once that secret has been disclosed to the world, it's no longer a trade secret and the value has just gone away, right? So here's some, sort of well-known trade secrets or not so well-known trade secrets. So I didn't know this, but the nooks and crannies in Thomas's English muffins, the way they do that is a trade secret, the recipe for and how they cook it. Google, obviously, if you recall, Anthony Lewandowski worked on their autonomous vehicle program for a while and then decided he'd had enough with them, took all the trade secrets and formed his own startup called Otto that was then purchased by Uber, ATG. And so it resulted in major litigation between those two companies. Anthony is now, I think, facing 18 months jail time, although he's still out waiting until the pandemic is over, but I think he will have to serve because theft of trade secrets is a crime, as well as being a civil wrong. WD-40, I didn't know that. That was also a trade secret. Coca-Cola, Dr. Pepper, Twinkies, which I think is hilarious, and Listerine. These are all, nobody knows the recipes outside a select few within the company. So when you're looking at what you have within your company, you're trying to decide, hey, do we keep this secret as a trade secret or should we patent it, right? Setting aside, what investors want to see, which is typically, that you check the box, that you filed patents on things that you think that you can maybe license. But, you have to decide, okay, is this something that's patent eligible? As we talked about, some things are not. So you definitely want to keep those trade secrets to the extent you can. Is this something that when incorporated into a product can be reverse engineered? Somebody could take it apart and figure out how it works. Like, for example, just out of thin air, what if you came up with a device that can take a single drop of blood and run every test known to mankind on it and tell you, whether you have a certain disease or something crazy, right? Like that. Who would ever do that? If somebody could buy that box, open it up and figure out how you're doing it, then you shouldn't keep it trade secret, because the second you sell one, you've given up the trade secret. That's something that should be patented to the extent it can be. Can you keep the knowledge confined to a small group? Are you concerned about employees coming and going? As a startup, often people will leave for whatever reasons, another opportunity comes along. Can you make sure they don't disclose it to anybody? And is there any interest? Is there any value within your business model of licensing what you have? Let's switch quickly to trademarks and copyrights. These are with startups, with young companies, slightly less important in my view, but nonetheless are important, right? So trademarks are anything that you get your customers to associate with your goods, right? So it is a name, symbol, color, like John Deere, the green color of John Deere is a trademark for all their tractors and farm equipment. Pink, Owens Corning fiberglass. Nobody else can make their fiberglass for their insulation pink because they have a trademark on that. The sound associated with Harley Davidson motorcycles is trademarked. I'm not sure exactly how that works in practice, but it's probably more of a novelty trademark than anything. But I think Intel Inside, that dun 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 dun, I think, I hope I haven't violated something there, but no, that's somebody, that is Intel's trademark as well. These rights come from use in commerce, right? So you can file for a federal trademark registration, and I highly recommend you do if you're going to sell something in more than one state. But they come from actual use in commerce. So you can't get a federal registration unless and until you can prove that you sold something across state lines or in another country. They can last forever if they're continually used, but in just about every country I've dealt with, you are required to prove that you're still using it at certain intervals. In the US, it's every 10 years. And I think in Canada, it's every 15 years. But regardless, you need to demonstrate that you're using it so that customers associate that mark, that name, that logo with you and you alone. Some examples of trademarks that people are familiar with. I mean, you look at this and you know exactly what the product is. That's a very strong trademark. I like the FedEx one. I always put this one on here because I don't know if you can see my cursor, but there's a white arrow between the E and the X suggesting motion, which I think is really cool from a graphic design standpoint, but that's neither here nor there. All right, benefits of federal registration. So let's say somebody is infringing your mark. They're using a mark that is confusingly similar to yours, and you want them to stop. You file a lawsuit, you go into court. If you do not have a federal registration, the burden of proof is on you to prove that you own the trademark, that customers associate you with that mark and your goods and services with that mark. How do you do that? Survey evidence, which is crazy expensive to develop. So if you have, on the other hand, a federal registration, you can just walk into court and wave that registration over your head, and you shift the burden of proof to the other side to say, hey, you don't own it. It's always better to put the burden of proof on somebody else when you're in court, because it's hard to prove stuff. So another benefit of registration is this notion of constructive use. The second I file a trademark application on behalf of a client, everybody can see that I filed it, and they can see who owns it, and they can see what goods or services it's been filed in association with, right? The benefit of that is that somebody else in some other part of the country who's thinking about adopting that mark, they may see your application and say, you know what, they're ahead of me in line. I probably should adopt something close to that because I have national ambitions as well. So the notion of constructive use is, I don't have a registration yet I'm on the registrar on the registration system, so people can see that I filed. And this last point I put on because I just had a situation. I had a client come to me and they'd been using a mark in a local geographic area for 10 years. Thought that they owned it, and they did own it through use and through people's association of their services with their mark, but only in a certain geographic area. And it turns out somebody else, one state over, was doing the same thing, but they had filed a trademark application and it matured into a registration for virtually the identical mark. My client was forced to change to a different name if they wanted to expand. The way that it works is, you're a common law user, you've been using it in commerce and don't have a registration. Somebody else has the identical mark and they have the registration, but it's after you. You are technically frozen to the geographic territory. You can only use the mark where you've been selling it thus far, and you can't expand any further because the other party will have constructive rights everywhere else in the country. They're after you, but they got a federal registration. So I think anybody who is going to sell something in more than one state or provide services in more than one state should think seriously about a federal trademark registration. And then quickly, I always talk too much. Getting close to the end here, so just quickly, copyright. Protection for original works of authorship. I think people mostly understand this. It's performances, it's art. Just had a situation where somebody hired an intern for their marketing group, and that intern pulled a picture off the internet. They didn't have rights to. They erased the copyright information about it and used it on their website. And they used it for 1 month. And then took it down. And guess what? Somebody found it. There's now software that will scour the internet and look for identical images, like the image search in Google, and they will find you and they will sue you. So don't do that. But copyright protects these works of authorship and provides the owner with exclusive rights to performance, reproduction, preparing derivative works, which is basically the same picture, but slightly different. And that is kind of subjective, but just be careful. Oh, one more thing, protection arises upon creation, but you can't sue somebody for copyright infringement in federal court unless you have already registered a copyright. So you need to, it's like a $70 filing fee. It's very inexpensive. It's more of a recordation. It's not an examination. They're not going to say, hey, somebody else filed for the same thing. If you register your copyright prior to discovering somebody's infringement, you can also get statutory damages and attorney's fees for enforcement. So that's a reason to do it early, much like trademark. Here's the summary. Patents are how stuff works. Functional technological developments, new, useful, non-obvious. Trade secrets gives you a competitive advantage. You keep it close to the vest. You lock up your employees. Trademarks are the goodwill of your brand, association between the mark or the name or the logo and the source of goods or services, right? In the consumer's mind. That's what trademark is. And finally, copyright protects the creative expression of ideas. You must register to enforce though. Okay, at this point, I'm going to hand it over back to Yan to introduce our speakers.
Thank you, Carl. Okay, so our three other speakers here have all interacted and adopted different ways of IP protection during their own startup operation. So we're going to have a small panel here for them to share some of their experience and things that which they had known before going to the IP discussion. So Frank, I'm going to pass it on to you first to let you share some of your experience.
Okay, great. Thanks a lot, Yan. It's a pleasure to talk to all of you on the webinar. So I'm just going to share a couple of quick perspectives before handing off to the rest of the team. I've been an entrepreneur first in the solar industry for 12 years and then in building materials for the last 3. And a couple of things to think about when you think about, founding a company or launching a company and sort of how to think through the IP. Yeah, I think the first thing, which is actually, really fundamental, is to incorporate and actually have an entity as quickly as possible. And I think this goes actually even beyond, intellectual property, because until you've actually, created a legal entity under which you're doing work, you don't have a receptacle to receive money, to transact any type of business, including patents. And I think certainly from the perspective of most of you, if you're in startups, you're going to be raising money and talking to corporate partners. The longer of an operating track record you have actually as a real company is always going to benefit you. I think the second thing, going back to what Carl talked about in terms of the different forms of intellectual property protections, to be really comprehensive, because I think even with things as simple as the trademark of your company's name or a copyright, I think it can't be assumed that companies that are working on technology are only doing patents. In fact, patents rarely make up the most substantial piece of your IP. I think in the case of the companies I worked in, it's actually been know-how and trade secrets. Certainly in companies that are more consumer-facing, things like trademarks can become much more significant. So, but patents are obviously really important. They're pretty fundamental in business, but it's far from the end-all be-all, from an IP standpoint for entrepreneurs. And then I think the third thing to think about is like the mechanism from which your IP is deriving is going to dictate a lot of your decisions around how you sort of structure your ongoing IP interactions going forward. So in the case of Scion, my previous company, which was doing solar manufacturing, our IP was internally generated, so we did spend quite a bit of effort to file patents, but we didn't have to license in any technology, fortunately, as a result of that. But then we did enter licensing and joint development agreements with some pretty large, corporations, including Taiwan Semiconductor, who's the largest chip manufacturer in the world, and then the Korean Development Bank. So I think in that case, the protecting the IP was all about protecting what we generated. But then my current company, Leatris, actually my father's a CTO. He had invented some of the technology, through a company that he founded that does, sort of general nanotechnology R&D. And then, this company was something we specifically wanted to launch to focus on research in, the building materials and insulation space. And so what we got, which I think is a common mechanism for licensing IP from other companies, is a perpetual exclusive, worldwide license to the technology, for that field of use, which basically in plain English means that you're the only person that can use it, and you can use it forever, you know, unless the agreement's changed. So I think that's a pretty common license structure if you're taking something out of a company. And then I think typically there may also be some type of a joint development, you know, agreement or some other, you know, type of interaction that allows you to continue, you know, interfacing with that, you know, organization to the extent that they may develop things, you know, sort of by accident or randomly that, you know, you could still use. You know, so I think those are a couple of things to, you know, think through relative to taking it out of a company. Of course, there's also the situation of taking it out of a university. And then I think Tom, you know, as I did at Scion, you know, has a company that's internally generated IP. So this is a great segue, I think, for the other folks to talk about their experiences as well. And then we'd be happy to take some questions along with Carl also.
Great. Should I pick up? I guess. Thanks, Frank. Hey, hi everybody, and thanks, Frank, for the segue. Yeah, and that was an interesting point about the kinds of licensing. Hi everybody. My name is Tom Mills. My company is Pace Controls, as Jan said. We're actually both a software and a hardware developer. We've actually worked with DOE happily, you know, and NRO. I look forward to coming back to NRO when NRO opens again. I think, like a lot of federal offices, they may still be closed this month, but you know, basically our intellectual property, to the point of this webinar, and thanks very much, Carl, for that great intro. It's both machine learning software, particularly for thermal processes, heating and cooling, commercial HVAC and refrigeration, but also other types of heating and cooling. And then edge, the hardware side is edge hardware, because you really have to connect the thing that is going to be, you know, subject to machine learning. And so we, as Frank said, we not only generate our own IP and are generating more and have a tech roadmap, which all of you are thinking about, where do we go? What do we focus on? What are our priorities? But we're also working with, in particular with Hitachi, which of course is very large company with lots of IP, you know, 950 divisions, I think, plus. And so we have both our own IP and generating more, Hitachi's IP, co-development, and in that place of co-development, you have the potential for improvement IP, and who owns that? What are the rights for that? So it's definitely a portfolio management process, you know, and you know, I would say, and we were talking yesterday about, you know, takeaways. We wanted to provide news you could use basically in this webinar, and you know, Josh will come after me too. But one of the things that I thought was great is where Carl started with that, and Frank just touched on the difference between patented IP, or IP where you're going to go after a patent, and then more the trade secret and proprietary realm, where you don't disclose it, where, you know, it's the Coca-Cola formula and things like that. And in fact, we, you know, like a lot of tech companies, perhaps like your companies, we have both and we manage both. And I think, as Frank said, I would agree that most companies have both, perhaps some even more in the proprietary and trade secret. From our standpoint, we, you know, as a cloud-based company, we have lots of machine data, and there's a lot of insight that you can gain from that. So, you know, that you don't have to disclose. So it's definitely something to think about first, and those gating questions that Carl listed, I thought were very good, and in, you know, in terms of deciding what to do on what. We, in terms of managing and in things with patent counsel, first of all, get patent counsel. We would suggest. One of the things I think that we've enjoyed a good relationship with our primary patent counsel for a number of years, and you know, they've given us some good advice, we think, and I think you know, just two things that come to mind. We do, to Carl's point, we do file internationally. We do file PCT, and as Carl said, if you get a patent counsel and you're filing internationally, for some of you, you know, you're already there. For others, this is sort of part of your plan, that your patent counsel here in the States, if you're based here in the States, will have, you know, what they call associates in other countries. Those associates will be more or less in charge of the filings in those countries, you will have to pay maintenance fees. And as you know, I think Carl pointed out, it does cost money. So, you know, it's all part of your business model. But two things I can offer is that, you know, sort of good wisdom was in terms of international filings. One of the things we first were told was, well, you know, you want to file in the places where you expect to find your best friends and your worst enemies. So best friends, worst enemies. Made sense to us. And the other thing that, and this is a bit of a chestnut, but it's important, right? Because you're a team and you're creating IP and you're innovating and things like that. The other bit of good wisdom is don't leave anybody off of patent filing. If you do decide on a patent filing that deserves to be on there, but also don't put anybody on who doesn't deserve to be on there. So, and it could be, you know, if that inventive step were contributed by a team member, it might not have been that, you know, may not have been Knights of Midnight Oil, that sort of thing. But if it's novel, useful, non-obvious, and it was an inventive step, you really ought to consider, you know, and talk with your attorney on whether or not that name should be on the patent filing as well. You know, just finishing up, one of the things I think we wanted to do, and this may be useful for some of you as well, an explicit part of our business model was to find partners with whom we could work, larger partners whose interests were aligned with ours by virtue of the fact that we're creating new solutions together. And Hitachi's been a great partner that way. I've been working with them since 2017. At the same time, you know, where you're dealing with a large organization, it's good to, you know, sort of, it's almost like exploring, you know, we have essentially two home divisions, if you will. And then there's, just recently, there's been sort of a cross-divisional organization that is helping to advance, you know, Hitachi has some very strong goals and commitments in climate change mitigation. So there's sort of a cross-divisional effort called, you know, that's under the rubric of social innovation that we can work with, but, you know, sort of find your home, if you will. If first we would be advocates for, you know, finding larger partners who can be aligned with your interests, and secondly, sort of finding your home there. Let's see, I think the only other things, and I'll, you know, turn it over to Josh because I know we're coming up on time. In terms of some of the ways to work with some of these partners, there will be, I think I touched on the idea of you have intellectual property, your partner has intellectual property. You're going to work together, and that may result in follow-on intellectual property. Typically, it's called improvement intellectual property. And what you'll want to do ahead of, you know, that agreement, in your licensing agreement or in your joint development agreement, is anticipate that and figure out how it's going to be, you know, managed, right? And there's, you know, your patent attorney can give you advice on this. There are models out there. You can read about things out on the internet. One example that, you know, is quite straightforward, as straightforward as it can be under the circumstances, is one where if, you know, A has intellectual property, B has intellectual property, there's a new innovation, right? C, let's call it, then perhaps innovation C is assigned to B, but A gets a royalty-free license, right? Simple enough, fair enough, you know, and maybe it's not free, maybe it's some limited thing, but just you know, anticipate before is a good idea. And with that, I'll turn it over to Josh, and then I know we want to go to Q&A.
Oh, Josh, I think you're on mute.
Sorry, the double mute. I was saying, thank you, Tom. Great to be here. Thank you, everyone. Can you hear me now? Ian? Am I good? Okay. I'm from InventWood. We're an innovator of a portfolio of advanced wood materials. I'd like to share some thoughts about negotiating with the University Tech Transfer Office to actually access the patents or IP that was created at a university, with the goal today of sharing some usable tips in how to license these technologies. And I think my experience in this area is a really interesting case study, in that InventWood was a faculty spinoff by a very high-profile professor who is a prolific inventor of a bunch of very high-profile technologies. And such, there was a lot of interest from all sides, from us, the university, and so on, in getting the license agreement worked out and worked out quickly. And honestly, I felt a lot of pressure in this regard. Nevertheless, the actual negotiation turned into an 18-month ordeal that I can say was probably unnecessarily exhausting for all parties involved. Now, I'm pleased to say today that we're on very friendly terms with the good folks in the University of Maryland's Tech Transfer Office, but a lot of time and trouble could have been saved if I knew then what I know now. So as they say, good decisions come from experience, and experience comes from bad decisions. So based on that, I believe I'm uniquely qualified to comment on this topic. And with that, I hope that you all can profit from my example to avoid some of the pitfalls that I fell into. So I think there are three high-level recommendations that I would recommend to anyone beginning a negotiation with the university. And much of what I'm about to say is true for any negotiation you may find yourself in. They are basically, number one, do your homework. Number two, build support for your cause. And three, think flexibly. So let me go through each of them. First, before you start any negotiation, make sure you do your homework. In the case of a university license, it means first looking inward before you reach out to anyone to start a negotiation. Ask yourself questions like, why do I need this IP? What am I willing to give up to get it? Can I move forward if I wasn't able to license this IP? And these questions sound really basic and simple, but getting this clear in your own mind will be really helpful once the negotiation starts. The next part of doing your homework is really understanding what the university's motivations are for the technology you want to license. So try to find out, are they getting a lot of inquiries about this IP? Is the technology you want to license in an area that the university wants to gain more recognition? Do they think this technology has a lot of potential, or maybe not? So these kind of insights can be very helpful. There's a term in negotiation studies called BATNA, which stands for Best Alternative to Negotiated Agreement. And it's basically a fancy way of saying, what will happen if the negotiation falls apart? For you, would it be disastrous if you couldn't license the IP? So if so, keep that in mind and make sure your objectives are reasonable. But what about the university's BATNA? Are they worried about being stuck with paying for a bunch of patents that they can't license out? And if so, what does that mean for you? So basically, it's always a good idea to understand your own and the other side's BATNA in any negotiation. Second, before you start any negotiation with the university, I'd really recommend building support for your cause. And this can be as simple as getting to know the folks in the tech transfer office, who are generally very nice and reasonable people. I'm not sure how things work now, but generally pre-COVID, there were a ton of in-person university-hosted events where members of the tech transfer office would turn up and even speak or present. Go to those, get to know who's who, and start chatting with them about who you are and what you're looking to do. Believe it or not, the tech transfer people are more often than not really excited to meet you. In my experience, they love to hear about new technologies, and they got into the job even for that reason. Also understand if they have pain points and see where you might help them. For example, if they want to showcase successful faculty spinoffs from the university and you're a faculty member, offer to present or publicize this technology. That in turn will build a lot of goodwill. In certain cases, however, you may need to establish your own credibility with them. For example, they may have a lot of conviction in you as a technical person, but they may have reservations licensing to you because maybe you don't have any previous industry experience. Or the reverse may be true. But whatever the case is, listen to their feedback, see if it makes sense maybe to bring in a co-founder that can complement your experience before you actually start the negotiation. And at the end of the day, the tech transfer folks want these technologies to be deployed throughout the world, and they want the university to look good. So if you can contribute to that, they'll be very receptive in working with you. My third point is, once you get into the negotiation with the university, or any negotiation for that matter, I really recommend you think flexibly. Another way to say this is that it's important to focus on outcomes, not on positions. So to explain, let me give you an example. When Inventwood started negotiating with the University of Maryland, my position was that I wanted to get rid of royalties to the extent I could. And for those of you who may not be familiar, royalties are a top line expense, meaning you have to pay them out before you pay any of your other expenses. So let's say you and the university agree to a royalty rate of 3%, and you have a product that you sell for $100. You will have to send $3 to the university for every $100 product you sell, even if it costs you $99 to make that product. So as InventWood was in a traditionally lower margin business of materials, I was very adamant in lowering the royalty rate as much as I could. So with that in mind, I pushed, I cajoled, I pleaded, I did everything I could to convince the tech transfer person I was negotiating with to lower the rate. And basically I didn't get anywhere. Instead, what happened was both parties took a step back and we started to think about how we could create a win-win whereby the university and InventWood could succeed together. And ultimately what we decided was that InventWood would give the university more equity in our company, which was something I was far more comfortable with in return for a meaningfully lower royalty rate. So another suggestion is that if you're very well funded or happen to have your own small fortune lying around, you can pay a meaningful upfront sum that can allow you to access better terms. So in many cases, the tech transfer office is often most concerned about being stuck with expenses for non-revenue generating patents. So paying up front can go a long way for them. So again, think creatively, understand you have these different tools at your disposal that you can utilize and think about how to deploy them. And then finally, just one bonus piece of advice, make sure you access all of the resources you can. I strongly recommend you get an attorney like Carl, who knows patents and has experience negotiating IP licenses. Reach out to friends, colleagues, mentors, whoever, who have gone through this process before, particularly those that have negotiated with the same tech transfer folks at the same institution. It will be really helpful. So anyway, that's what I wished I had known when I started the negotiation with the university a few years ago. Happy to answer any questions here or outside of the webinar if anyone's looking for guidance. With that, Yan, I'll pass it back to you.
Yeah, thank you, Frank, Tom, and Josh for sharing the insights. So now we're going into Q&A section. And I think some of our Carl and Frank has been actively answering some of the questions. So I'm only going to go through questions that are still open. So first question is, can you say how you work with patent counsel outside the individual patent process, specifically to develop an IP strategy or picket fence around your technology? We have used patent on a molecule for disease treatment, but need work to protect that use. I feel like I don't know what to ask for other than, can you help us patent this? We need their involvement in a strategy for development going forward, but I'm not sure what to ask for. So I think this might be a question, I don't know, Carl, or just to the group in general.
Sorry, I was on mute. So that's a great question. I think this goes back to something Josh was saying. You need to make sure that you have, that you're talking to a patent attorney who has experience with strategy. A lot of, much like tax attorneys and accountants, like you ask an accountant a strategy question, they're not going to answer. They don't know, right? They're afraid to answer, in my experience. But a tax attorney is going to be able to tell you how you can avoid tax in the following year. Patent attorneys are the same way. Some patent attorneys just want to write patents and don't know anything about business. And other patent attorneys are really into, understanding, the competitive advantages and, how we can, create a strategy that will maximize your profit or maximize whatever it is you want to maximize. I actually happen to like working on that side. Like, how should we write this particular patent? What countries should we go into? What's the gross domestic product in these countries and the average temperature? It's like, it really kind of, you have to think outside the box on these things. So yeah, I would say interview people and find somebody that you can communicate with. Tell them you want strategy advice and not just a patent. Those are my 2 cents. I don't know if anybody else has any thoughts.
Well, I would just, I'm sorry. Hi, this is Tom. I would just, I completely agree with all that, with what Carl just said. I would just add maybe 2 things. First of all, it's like the old ad, the knowledgeable consumer is your best customer. before you go to your patent attorney, there's the internet can provide. Google Patents has been out there for a while, and can really be useful in a keyword search. It isn't the equal of, let's say, of the breadth of a formal search that an IP firm can do, but it'll get you a long way. And just looking for what is out there, it also won't. It covers what's issued, right? And then that's the other part of it, because then there's, as Carl explained, there's a considerable pipeline that is not visible. But the environmental scan is a part of being a tech company. So see what other people are doing, one of the things I think we try to do in our environmental scanning, our strategy guy is formerly ran an EFT for clean tech. So, he's pretty plugged in, but just to do the research first, and then see if you can then engage with counsel who can help just ring fence what you're actually filing, would be what I'd suggest.
Let me just jump in here real quickly. There's something I didn't cover that I probably should, and thanks for that, Tom. Patents, when you file a patent application, is going to be secret for 18 months, right? If you say that you will just seek protection in the US, you can keep it secret unless and until it issues, right? Nobody can see it. If you want to seek protection anywhere else in the world, you must allow it to be published. So the end result is that the information you're getting when you do a search on Google Patents, which is fantastic, by the way, even though they lag about a month, 3 weeks to a month behind the USPTO. Their interface is so much better that I highly recommend it. But that information that you're getting is at least 18 months old in terms of what's been filed. So just keep that in mind.
Yeah, one other thing I would add, some context to this discussion on sort of searching and thinking about issues like, your freedom to operate and potential infringement is like, listen, at the end of the day, like if you're a business person, you've got to sort of drive toward, what you really need and what investors and partners want. So I'd focus 99% of that effort on what big incumbent players in your space are doing, because those are the people that have a war chest of patents. Those are the people that actually have the capability to prosecute them. And I think you'll find that, there's probably some odd one-off stuff being done out there by single inventors, but the people that you're really going to be looking out for are large corporates, and then emerging like venture backed and other sort of well-funded, startup, type companies. And I would really focus the effort, thinking about those players. So if you're in a space like I am, like building materials, where there actually hasn't been a ton of innovation in terms of new generations of products, we went into this sort of knowing who all the people were, that had done stuff in the space. So I think maybe we were a little bit lucky in that respect, that we didn't have to do a lot of legwork. Maybe if you're in a space like, the LED lighting or something that's a lot more crowded and litigious, that may be less the case. But I think in almost any of these, sectors, you're going to have a pretty good sense right off the bat of like who are some of the big names that you should be, focusing on, and including maybe who some of the even the specific inventors and institutions are as well.
Great. Okay, so we have one other question in the Q&A chat box. When using third-party data sheets in a software product, what type of legal considerations should be made? So this is a sounds like a software patent question.
Yeah, this is probably honestly outside the scope of my experience. So there's no database protection here in the US. There is in Europe, so it kind of depends on where you are. And are these data sheets open source, or is somebody claiming that they own them, right? How did you acquire them? Did you acquire them using a spider, or did you acquire them by an ex-employee, right? Are the circumstances of your acquisition fishy? Those are the kinds of things I would poke at, but I think my base response is that there is no inherent or way to protect a set of data per se, but there are ways to acquire that data sheet illicitly that could get you in trouble. I guess that's my sort of answer.
Yeah, one thing I'd
NDAs,
add here is
go ahead, sorry,
this question seems to be like super, super broad, because I mean, the word data could constitute, you know, anything, right? It could be numbers, it could be, you know, personal information, you know, so I think we need to know a lot more specifics, but I think thinking about it from a business perspective in terms of using data, like, I mean, first of all, if it's anything obviously that's marked confidential or proprietary, then it's going to be, you know, subject to an NDA. If it's out in the public domain, you know, I would say for informational purposes, if you're looking to share it in marketing collateral or in, you know, vendor communications or things like that, I mean, I would generally, and again, it's something you should probably consult with your counsel if it's significant. But I mean, I think I would generally feel comfortable using it if it's you know, properly attributed. I think a couple of things to be mindful of, or if it's a, you know, government contract or any other type of co-development contract you have with a partner, there's probably a, you know, data management plan, or there's probably data management and confidentiality provisions that are built into those contracts. And I think you need to make sure that you're you know, compliant with those. And then I think, I don't know if the data you're talking about even extends to this, you know, into this realm, but I think anything that's personally identifiable or otherwise sensitive is absolute no-no to, you know, share, because I think that would constitute a breach of privacy. And I think, again, depending on the nature of the, you know, contract that you're working under, the, you know, business that your company is in and where you're disseminating it, I mean, that could have definitely very significant, you know, liability and reputational implications. So those are, I think, a couple of things to think about. But again, that's, term data is really, really broad. So if I think you have a more specific example, we'd be happy to provide more insight offline.
Okay. So we have another question on, do you have a recommended form for NDA?
I can jump in on this one. Yeah, it's funny. Carl, I'd love to hear your thoughts too. You know, from our standpoint, we developed our own NDAs in-house, and they've been something that have been revised multiple times as our understanding of our business and the context in which we operate has changed. So I think I would invest in a good NDA. I wouldn't just grab one off a shelf. I think it makes a lot of sense to get one that's appropriate for your circumstances. And again, a good attorney would be able to draft that. We at InventWood have kind of multiple layers, so to speak, of NDAs. We have what we call a sampling agreement as well, which has to do with the transfer of samples and what kind of tests can be performed on those samples. So those kind of things, again, depending on the company and the technology you're working on, they vary so greatly. I strongly recommend working with an attorney for a specific solution rather than a kind of cookie cutter one that you might find online. Carl,
yeah, that's a great answer. You know, circumstances matter, right? Is it a one-way NDA or is it two-way? Do you expect that both parties will provide information that they don't want disseminated widely? I would say the base of an NDA is formulaic. The details and the things that are, you know, tied to your business are not formulaic, right? So you can pull one off the internet, like from Y Combinator or somewhere else where they have libraries of these things, and use it as a base. But you really need to think about the things that are important to your business that may not be covered. So yeah, I agree with what Jeff said.
Yeah, it looks like there's a follow-up too on the NDA question. I wonder if we should just answer that one real quick as a follow-up. Maybe Carl, the
caps lock key. That's funny.
No, do you have to get signatures every time you revise the NDA?
Yeah. Every time it's best practice, put it that way, right? So, and if they violate the NDA, you're going to be upset. So to the extent that you make a change, both parties have to agree to it, and both parties should at least initial it. Some NDAs will require that both parties have to, so all amendments have to be in writing and signed by both parties. Other NDAs don't say anything about that, but it is best practice to do so, and I would not have you not do so. Put it that way. Yes, is the answer.
Thank you, Carl. Okay, so this is probably the last question for today. Does making a patent overly detailed or complex offer extra protection against copying?
Oh boy. Only if the overly complex aspect of it goes to different embodiments, right? Different ways of doing that which you intend to protect. Right, so it's a car with 4 wheels with hubcaps that are spoked. It's a car with 4 wheels with hubcaps that are wired. It's a car, you know, it's like you could do that. I personally find that super annoying and difficult to read. Some patent attorneys write so obscurely that it's impossible to tell what they're saying. I do not subscribe to the opinion that that's a good thing, because I think at the end of the day, a judge and a jury are going to have to decide what the scope of the claims are. Scope is what the scope is. So I'm against that.
I would again I would say amen to that. I while you were mentioning that, Carl, I had in mind a patent I just recently reviewed. It was a process, an industrial process, and the reagent described maybe water, maybe. Well,
right.
Not, you know.
Yeah.
It's and so there's the things that you hold back, no, it's not water, it's our secret sauce. That's the whole point. But it's as part of this industrial process, right? So that balance again.
Sounds great. Okay, so with that, I think we're at the point to conclude today's webinar. First, I want to thank all of our speakers for sharing your insights and knowledge, and then thank everyone for taking the time to attending today's webinar. Hopefully everyone has obtained something that's helpful for your own situation. Yeah, with that, have a good day and bye.
Thank you. Bye.